Check one, check one, check one, check, 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 check. Test one.
Can you hear me? Okay.
Woo! Sorry.
Wow. All right.
All right, we're going to start in just a second, so if anybody needs to find them a seat or get close where you can hear or see or talk or... Hey, Brother Vernon, I know they've been leaving that door open when they sing because it gets really hot. So if you hear noise, can you shut these doors so we don't distract the sound? Okay. If not, if it's quiet, then I don't care. That's fine. But... Oh, could you hear me out there? Was my mic unmuted? Or you just heard me? Maybe if I actually turned off the... There we go. Okay, first matter thing, we have these handouts, and we got them in the back table, so if you don't have one of these or your couple doesn't... If everybody... There's probably enough for everybody to have one, but... and then there's also pens somewhere. Tanya may have got everybody a pen, but if you... They're also back there right on that table if you don't have a pen. Reason I'm encouraging you to have that paper, one, we're following along that paper, but the pen, I want you to write down some notes. We will try to get to some questions and answers, some Q&A later on in it, but as you guys know, there's a lot of material in here. We don't want to keep Susan here all night. We want to be able to get through the material at a decent pace. We want you to understand it, but she may answer your questions. So if you have a question, something pops in your head, just jot it down, and then we'll try to ask some questions at certain times. That way we don't get too slow and with all that. So is that good? You got that, Sierra? Is that on? Did you transition that? So we're already rolling. So, okay. Well, if you guys want to care to stand for a second, we'll just open up with a word of prayer, and then we'll jump right into what we're talking about tonight and get on the same page and roll with it. So if you bow your heads, we'll pray. Our Father in heaven, before we start tonight, we appreciate you. We honor you first. We thank you. I'm glad for this church, and I'm glad for these people, but I'm also glad for an opportunity in this life to help others, to understand, be wiser and smarter about the world we live in so that we can actually help people better or conduct our affairs better, more orderly, decently, whatever we can do, because I know you like all things to be done decently and in order. So we pray you'd help us to understand, to learn a little bit tonight. If this helps somebody, that'd be great. And God, and maybe if this just educates us so that we can help somebody else who's walking through this in the future in our life, that'd be great too. So we just want to be a help to anybody we can. So just help us tonight to take in this material, use it where we can, and just like you said, to be wise as serpents and harmless as doves. And we pray these things in Jesus' name. Amen. All right. So we're going to get into this presentation. First of all, this is Susan Ranson. So everybody give her a round of applause to welcome her. She is part of the elite group that I am part of. That is the Fair Playing Elementary Fraternity, class of 2000 edition. There was only like 20 of us.
Maybe 15.
Maybe 15, yeah. That's back in the good old days. And we was just kind of a one-grade schoolroom, so we was together. I joined him at second grade, and we was together the whole time, until... So anyways, grew up with her and know her very well, and she has done very well and got associated, got her bar, been working with Rob Fisher now for 6 months, and regardless what the Bible says about lawyers...
4 years.
Oh, you've been there for 4 years.
Yeah.
You had your bar for 6 years.
Yes.
That's what you told me. Okay. She is very well schooled. She did this presentation. She's going to talk about this at J&M for us. It's very educational, very helpful. Just want to remind you what we're doing. This series is dealing with death, and this is one of the things, whether you like it or not, these legal issues, it's part of it. It's just part of it. And the goal of tonight is, in the book of Ephesians chapter 5, he talks about the ministry and how God gave us pastors, teachers, evangelists, and all these things. He didn't name everything, but I think even lawyers, maybe, he'd be okay with it. He even gave us lawyers to help us with it, but he says for the perfecting of the saints, or in other words, the equipping, like to equip you to be effective in the ministry and in the work, and in that way, when you're coming in contact with people, just to know how to help deal with what you've got to deal with. So if anybody has ever dealt with death in a family or something like that, and you wasn't ready, it was unprepared, you understand the nightmare of having to deal with this on top of having to deal with the grief and the other things. And so tonight's mission is to give some understanding, some direction in your life, something for you to think on, chew on. At least one person in this county that you'll know a face and know a familiar name, that if you need to follow up and do more things to get yourself squared away or your family, then you'll at least have a point of contact. So with that, she's going to direct pretty much what's going on here and grab this presentation. So Season, it's all yours. You can take off, and we'll ask questions and answers at some different times, but take your notes and grab your presentation and get ready to be educated.
All right. Nice to meet you guys. And if anybody wants to know which Ranson I am, I was Bo's daughter. I was Kate Ranson's granddaughter. I don't know how many of you know any Ransons, but the good ones. If you know bad ones, I'm not related to any of them. So, all right. So the first thing we're going to talk about, which people are always really surprised that this is the first thing I want to talk about, it's about powers of attorney. If I have to tell anybody the one thing that I wish everybody would get done, it's not wills. It's not a living will. It's a power of attorney. How many people here currently have a medical power of attorney? One person. One person in here? Or did you go to the hospital and they said, hey, do you have a medical power of attorney? And
they made you do it?
They made you do it, basically? At the VA?
The VA made him do it.
The VA is pretty strict about it. They want you to have those powers of attorney. And the reason for that is that what they want nowadays is they want paperwork that says, these are the people who can make decisions for you. These are the people that, if they need to make medical decisions for you because you can't make them for yourself, this is the person who's going to do that. But they also want paperwork now that says, this is the person who can sign for me, who can talk to the bank for me, who can talk to my insurance companies, who can talk to my utility companies. Nowadays, it's not good enough to just say, I'm such and such's daughter, and she said it's fine. Here's her account number. They're going, no way. Show us paperwork that says you can do that. Used to be you could go into any bank and say, hey, I'm Bo Ranson's daughter. He said for me to get $100 out of his account. They'd go, do you want that in 20s or 10s? They'd hand it right over. They want something from the bank now that says, this is a person that we can talk to and release money to, because it has become an issue. People have just been going in and they have gotten into people's accounts, or they have called the insurance companies, or they've cut off people's utilities. So they want this paperwork, and that's what powers of attorney do for you. They give you paperwork while you're alive that says, these are the people who can speak for me. Now, when we talk about medical, that's very basic. That's super simple. That's your medical stuff. Who can turn off the machines for me if I wanted to? Who says that they're not going to put any sort of feeding tubes? Anything like that. You know, if you can't make a medical decision for yourself, that's what a medical power of attorney is. And one of the questions people always ask me is, can I do co-medical powers of attorney? And the answer is no, because that's a bad idea. Because if you get one person who says, Mom would never want to suffer, it's time to let her go, and the other person saying, hook them up to everything that you possibly can, what's the hospital going to do at that point? There's nothing they can do. And don't assume that just because you are married, that is the person who is your power of attorney. Especially during COVID times, sometimes it was the person who dropped you off at the emergency room. That's who they considered to be the person who was going to make your decisions. My mom was my grandma's power of attorney, but my aunt was who dropped her off at the emergency room. And they would not talk to my mom until she could produce that paperwork. And she was a nurse at that hospital. So they take that stuff seriously. Now, the good thing about medical powers of attorney is, as you can tell us, you can get them right at the hospital. So next time you are at CAMC or you're at a WVU hospital, get one of those free medical powers of attorney. Stop by Jackson General, pick one up. They will notarize it for you, put down who you want to be a primary, make sure you put down a secondary person. Some people don't like putting secondary people down, but that's really important, because what if your primary person is your spouse and they have some sort of, let's say they have, they end up with having a stroke or they have dementia, and you haven't put down a secondary person to back them up. You need to always be thinking about who's a good backup person when it comes to powers of attorney. So, any questions about medical powers of attorney? Those seem pretty self-explanatory. When you are not able, that's the key with medical powers of attorney. As long as you are still capable of making your decisions, you get to make your decisions. It's only until you're not able to make them that person gets to step in.
What happens if that comes up and you don't have
And you don't have one? Then it can come down to who dropped you off. So, or which child gets there first. So, and if you are married, you know, obviously you think that the default is going to be there, but what if you have a blended family? What if you've got, this is your second spouse, but you've got children from another marriage? So that's why it's so important to kind of line those things up together and have those conversations. Who's going to be the person who actually ends up making decisions for me? So, okay. Now the second one that we want to talk about is the durable power of attorney. The durable is the one that can do everything else. Everything that you need it to do, that you can do for yourself that's not medical, a person with your durable power of attorney can do. They can sign property deeds for you. They can talk to anybody on the phone for you. As long as you have designated them to do that, if you go out on vacation and you say, hey, there's a piece of property I want to buy, but I'm not going to be back in time to sign the deed, can you take my power of attorney and sign the deed? They can do that for you if you designate them to do that. So it's very important when you pick somebody for your durable that it's somebody that you trust to act in your stead. That may be a child, it may be a spouse, it may not be. So you want to be really careful about that, because once you've given them that power, it is very difficult to get that power back. Now, if they start doing things that you didn't want them to do, so let's say you have a durable power of attorney and it's just sitting in your sock drawer. That's what we call a durable. We say it's a sock drawer document. If you need it, it's there. If you don't, you know, great, you never needed it. But if you have somebody who finds it and they're marked down, maybe you've got a child who takes it and says, you know what, I'm going to take $10,000 out of mom's account. They go down and they do it. They spend it on themselves. You'd have to sue them to get that money back. So you want to make sure that whoever you designate as those powers of attorney are people that you trust who are going to act in your best favor. Okay? Any questions about durables? Does anybody here have a durable power of attorney in place?
Jay, you got a question?
You got a question?
Go ahead, Jay.
Go ahead.
What's the difference between durable power of attorney and having someone ruled mentally incompetent?
Okay, so that's a great question, because that's what comes up when you don't have any of those things. So let's say you have no medical power of attorney and you have no durable power of attorney, but let's say somebody needs to make decisions for you. That's when you have to go down to the Jackson County Circuit Court and be named somebody's guardian and conservator. And those are actually two different things. Guardian is the person who makes decisions for somebody's body, their well-being, where they stay. Conservator is the person who makes the decisions about their money. Now, they can be the same person, but they don't necessarily have to be. So if you become a person who is not capable of making those decisions and you don't have a durable power of attorney or a medical power of attorney, you have to go to the Jackson County Courthouse, petition to become that person's guardian conservator. That is an expensive thing. So in our office, we charge $75 for a medical power of attorney or a durable power of attorney. Sometimes a guardian conservatorship, that can cost anywhere from $2,500 and up. That's a lot of money just because you didn't want to designate somebody while you were still capable of doing that.
Is there any advantages of having that over the durable power of attorney?
The only advantage I would see would be if you have a very contentious family who does not trust you. So if the mom has designated you as the person and your brothers and sisters are going, she would never have done that in her right mind and we don't believe that, it's a good idea for you to be declared that, because once you are somebody's guardian conservator, not only is it a tougher thing to get through because it has to go in front of the judge and the judge has to sign off on it, you are also accountable to the court from then on. So every time you spend money out of her account, you have to account for that. Did you use that for her goodwill, or did you buy yourself a Corvette? And somebody's going to be paying attention. And that person's name is LaDonna, and she's the nicest person ever down at the courthouse. So, but yeah, sometimes it's better if you have to go through that, because you've got that little layer of protection that says, the court said it was going to be me, and I have to be accountable. So if they ever have any question about that, you can show them. Here's all my books. Here's where they signed off on it. Like if you sell mom's house, like let's say mom can't live by herself. You've been named her guardian conservator and you get the order that says, sell mom's house, but you have to use the money for mom's care, which is how that works. You've got something from the court that says, we said it was a good idea, we signed off on it, and we let him do it, and here's where he put the money, and here's where he's been using the money. So.
What if your mother's incompetent, but she doesn't realize she's incompetent?
that again is something you probably want to go through the courts to see. So, but if she is incompetent, if you brought her to my office and she didn't understand what she was signing, we'd never let her sign. So that's why it's important to do it in front of a notary. And all powers of attorney have to be signed in front of a notary. It's for the notary to say, did you really know what you were signing? Because then that becomes a litigious question. Did you take mom to an attorney, and did she really know what she was doing at the time? And it can get a little dicey. So, but what you hope is that you do these things early enough that you've got them into place, and also that you've had these discussions with people. Okay, you know, I put this person in charge of my finances, my durable power of attorney, because they're good at keeping my books, and you know they'll talk to all the people they need to. And I put this person in charge of my medical care because they have medical experience. They were a nurse, you know, that kind of thing. So, but always open communication is the best way to avoid somebody coming back later and being like, Mom would have never done this. She didn't mean to cut me out. Even if everybody else in the family would say otherwise, that's where things come up. So, any other questions about powers of attorney?
I just wanted to ask, going back to the medical, do they still have a healthcare surrogate here in West Virginia?
Healthcare surrogate.
Yeah, DHHR, like no family, like if somebody lacks capacity, and the legal terms, speak for medical terms, if nobody in the family is found to make a medical decision, they'll usually name DHHR healthcare surrogate. Is that only for that entity that can do that?
Only for the cases where they would have nobody that they could find to do that. I did have a case not too long ago where they had to name DHHR because we had family he hadn't spoken to, they couldn't get a hold of him, and it was an emergency situation. So in those cases, usually the hospital attorney will decide that's who we're going to let make that final call on what we're going to do here. But sometimes also they'll just look for a neighbor. They'll try and find any person that knew you, because that's what you want. You want somebody who at least has some vague idea of what you really wanted your end of life plan to be. So, okay?
So, yeah, and again, if you got any other questions about it, write that down. We can revisit that and swing back through on some of those things as well. And
Yeah.
I know she got it on your paper right there. You can read it in the middle. These things are only good while you're living, and that's
Yeah, very
once a
important.
person passes away, you get rid of them.
Yeah, that's important. Once you pass away, your powers of attorney are no good anymore. They are living documents. So if anybody ever comes up to you and says, hey, I've got mom's power of attorney, mom's been dead for 2 years, that power of attorney is no good.
Doesn't
And we
matter.
have had people come up every now and be like, I was their power of attorney, but they're not alive anymore. So
You don't make any
No.
decisions after they pass away. Your
Exactly.
decision-making ability's gone.
you're gone. Okay. Well, let's go on to the next thing that is really important that we've been doing a lot of, and those are transfer on death deeds. So has anybody heard about those, or has anybody executed those?
We're talking about property.
Yes. Transfer on death deeds are for real estate.
Right, yeah, I talked to a lawyer up in Parkersburg about this. Yeah, go ahead.
Okay. Well, good. No, I'm glad we've got somebody who's heard of them because they're fairly new. So what transfer on death deeds are, what they started out to be, was they were a solution to fix the 5-year look back problem. So who's here has heard about Medicaid and the 5-year look back? Okay, so you've heard about that nightmare, which was, okay, if you wanted to qualify for Medicaid, which is different from Medicare. Medicare is the normal, you sign up at 65, you pick your plans, you do your thing. Medicaid is the free health insurance. You only qualify for Medicaid if you make less than $2,600 a month in income and you have less than $2,000 in assets, which does not include the house you live in, and it does not include one car. So it is actually extremely difficult to get down to Medicaid level for most people. It is not easy at all to get there. So, but one of the ways that they help people do that to get them to Medicaid level is they said, okay, if you're trying to get to Medicaid level, if you'll move all of your money and you'll move your house and you'll move everything out of your name 5 years before you think you're going to be on Medicaid, then what we'll do is we'll say that's good enough. We won't look back any further than 5 years. You do all that 5 years in advance. If it looks like you're Medicaid level at that point, you've got less than $2,000 in assets, you're making less than $2,600 a month, great, you're going to qualify for Medicaid. How many people here like the idea of having to move all the stuff that you own in your life out of your name into your child's name or your grandchild 5 years in advance? And who knows 5 years in advance that they're going to need Medicaid? Please raise your hand if you have that kind of foresight, because I want you to pick the lottery tickets next time. Exactly. So everybody hated that. And that's where you started hearing those horror stories where people would say, oh my gosh, Grandma died. She died with her house in her name. She owed all this money to the nursing home. We had to sell Grandma's house in order to pay all her nursing home bills. And it was a PR nightmare. So what they did is they invented what's called the transfer on death deed. So there's a couple awesome things about the transfer on death deed, and it only affects your real estate that you actually live on. So it doesn't affect like your hunting camps that you may have in Clay or Word or something like that. Has to be the home that you live on, and that can include however much acreage. If you own 400 acres, as long as it all touches and you live on it, that's fine. Doesn't just have to be your house. But you go ahead and you execute a deed to whoever it is you want it to go to. Kids, friends, whoever you want it to go to, we go ahead and put it on record while you're alive. Has to be done while you're alive. But it has no effect until you have passed away, you and your spouse, if your spouse is on there as well. So in that time, you have complete control. If you have a homestead exemption, you keep your homestead exemption. You need to borrow money against the property, you can borrow money against the property. You want to sell out, you're done with these West Virginia winters, I'm done, I'm getting out of here, you can do that. Whoever you have transfer on death deed that property to, they have no say in it. They don't have to sign off on anything, they don't have to know you've done anything about it. But once you have passed away, or you and your spouse have both passed away, that property goes automatically to them, and it becomes what's called a non-probatable asset. So when Medicaid goes back, and they want to put a lien against what your estate was to try and get their money back for whatever they've paid out for your health care or for your nursing home, they can only put a lien against what's actually in your estate at your time. Well, for most people, their biggest asset is their house. So that's why you want to do something that makes your house a non-probatable asset, so it will go automatically to whoever it is you want it to go to once you've passed away. It's great. You can leave it to all four of them.
Yeah.
You absolutely. You can put as
Yep.
many people on there as you want to. I don't recommend it. Only because, and this is something to think about when you do any kind of property transfer, because you also see, because what people used to do back in the days, they used to do life estate deeds. Those were really popular to help get people to Medicaid level. So you would say, okay, I'm going to deed the property over to you, but I'm going to get a life estate, which means I get to live here until I die. And then once I die, the property goes automatically to you. That was great, and it sounds like a transfer on death deed, but you actually have less power than you have with the transfer on death deed, because if you try to sell that property, these people that you have given that where you did a life estate, and then it was supposed to go to them once you've passed away, well, they have an interest in the property.
You're right.
So they have to sign off on everything that you do. If you decide to refinance your house to add on a new room, they have to sign off on the trust deed. If you have 100 acres and you want to give 20 acres to somebody, they have to sign off on all that. That's not usually something people like that much anyways. So that's why the transfer on death deed is so great, because it does protect you. It does exactly what the life estate does, which is protects you, turns that property into a non-probatable asset, but you retain the power. And that's what people really like about it. So.
Can you do that whenever they're already in the nursing home?
You can. They actually go into effect the moment they're recorded. That's why it's really important you have to do them before people die. And I have had incidents where I've had somebody pass away before we got the transfer on death deed recorded. So you want to make sure that you take care of that. And you can do them with your power of attorney. So let's say you've got somebody in the nursing home who has had dementia, they're not capable of signing. You can do a transfer on death deed with the power of attorney. The only caveat is, and we'll tell you this if we do in our office, you cannot do what's called self-dealing. So let's say in your case, you've got 4 kids, I'm going to say, okay, let's say you've named, what's one of your children's names? What is it? Jackie. Let's say you've named Jackie as your primary power of attorney, and you have dementia, and you haven't done this transfer on death deed, and Jackie goes, we got to get this done. So I'm just going to whip one off really quick, and it's going to be me signing for mom, and I'm just going to give the property to me. That's a huge no-no, because Jackie has cut out 3 of her siblings who are going to come back and say, Jackie, mom would have never done that. Unless it's true. Would mom have done that? Okay. In which case, we want to do that now so that if anybody asks, that was intentional. So, but that's what's important. When you do those powers, when you use those things in conjunction together, those powers of attorney along with doing property transfers, you have to do them in a way that you know you're acting in whose ever best step that you're acting in, but you always want to be up front. So you do have cases where you have people who have 5 and 6 siblings in a family, and 3 of them might say, I don't want this property. But you want to have something that says that they have agreed to that we're going to do this deed the way it is. And we usually have people sign just a little paper in the office that doesn't go on record, but you keep internally that, this and this sibling said, you know what, that's fine. I know you need to do this transfer on death deed. Let's go ahead and do it, but don't put me on there. So, any other questions about that? Has anybody had experience with one? Have they ever been the recipient of one, or? Brother in the back?
Well, he's not here.
Okay.
There, but we just had that 2 years ago, his wife passed.
Just had to do that.
Gotcha.
And I know she uses some terms that I think most of you know, but maybe not, but she'll cover up too, like probate. When she's saying non-probatable asset, it keeps it out of probate. And what that means is, and she'll probably explain it later, is when you have an estate or something like that, when somebody passes away, all that stuff, if it is probatable, it basically goes to and I don't know who that person is right now, and that you have to go see somebody, and they take all the liabilities and all the assets before you're allowed to get any of that. It has to go through this process. Well, what she's talking about being non-probatable means it doesn't get included in that process. So you don't have to go down and deal with that later when it stays out of that.
Exactly. And it'll help you, because we're going to talk about the new kinds of probate. I won't ask if anybody's probating the state. We'll get to that when we get there. So,
Okay.
But again, transfer on death deed is another one of those documents you have to execute while that person is alive. You cannot execute them after they've died. It does you no good. So you've got 3 living documents: powers of attorney, transfer on death deed. So now people always ask me, well, if I've got this power of attorney and I've got a transfer on death deed, well, what do I need a will for? The will's for everything else that you've got. That's your personal property. That's any cash that you haven't designated. Wills are really important because they also designate somebody who is going to be in charge of making sure your estate gets done. And also, the important part about a will is they make sure that that person doesn't have to pay a bond. Has anybody here ever had to administrate an estate? You're nodding your head. So they didn't have a will, did they? How much did you have to pay as a bond? Okay.
My dad had passed away. He was an only child.
Oh, okay. So you ended up having to administrate. How much did you have to pay for your bond?
No, sorry. That was a lot more than that.
It's based on the size of your estate. So if you have a sizable estate, $5,000 or $7,000 for your bond. That's expensive. It's worth it to get a $150 will just to not have to pay the bond, if that tells you something. So, okay. So there's 2 kinds of wills that you usually hear about. There's the basic will, which is what most of you are going to want. It's I'm married to Jack. I want all the things I've got in the world to go to Jack. Everything's going to him. If something would happen and Jack would predecease me, or we would die at the same time, I want it to go to my 2 kids, Jill and Jane, equally. And then if something happens and Jill would predecease me or Jane would predecease me, I want their share to go to my grandchildren. That's the most basic will that you've got in the world. Now, some people don't like to go that far. Some people come in my office and they say, I just want to leave everything to my spouse. And I'll say, do you have kids? We're going to leave anything to the kids? I'm not going to worry about that. Well, I worry about it. You know why? Because you always end up dying. Because you end up dying, and the kids come to me, and they say, here's Dad's will, and we see you left everything to Mom. Well, Mom's already dead, so what do we do? And I'm like, well, guess what? You get to be an administrator, so I hope your dad had nothing in his estate, or it's going to cost you a lot of money. So it's really important when you talk about basic wills, or when you come into an office like mine, that you be thinking ahead like that. If something would happen and your spouse would predecease you, where would you want your estate to go at that point? Do you want it to go to all your children? Maybe your children don't need it. Do you want it to go to your grandchildren? Be thinking like that. And then also, what if one of your children passes away before you? Where would you want it to go? Do you want it to go to your grandchildren? Maybe your grandchildren are really young. You would prefer it to go back up to the surviving sibling. The one thing that I would tell you guys to do, even with a basic will, and I see this all the time, is that a lot of people will just say, I'll just leave it to one kid and he'll know what to do. And that sounds great. They always say, he'll know what to do and I trust him. And I always remind them, you're not going to be here to enforce that trust level. Like my grandma used to say that to my brothers, her sons all the time, and she had 5 of them. I trust them. Well, yeah, because you're looking right at them and they'll do whatever they say because you're here. But once you're not here, that matriarch is kind of gone. So you got to be thinking about things like that. What you have to look at a will as, if I'm not here, how do I want this to go? And I need to lay this roadmap out in case somebody who I don't know as well or that I can't trust may possibly be the person who ends up executing all of my estate stuff. So, does anybody here actually have a will in place? You do. Okay. Hey. Well, that depends. Did you type it or did you write it? Okay, then yes, it does. People do ask me about that. So there's wills that you can write yourself. They're called holographic wills. I do not recommend holographic wills. I'm sorry. And I'm not just saying that because I'm an attorney and that's how I make my money. I promise you. It's because you don't know what questions to ask you about your will stuff. That's the reason. So do you mind if we talk about your holographic will a little bit? Okay. So how do you have it set up when you wrote it out yourself? Did you? Mm-hmm. Nice. I like that. Okay. Now, is she the only person on the bank account with you? Okay. So let's talk about that for a minute. Because there is things when we talk about probate and non-probate assets. So that's an important thing to talk about. So there are things that will not go through probate by virtue of the fact that they are designated with beneficiaries. So things like bank accounts where you have somebody down as a joint tenant on the bank account. If you have a spouse, usually you guys are right as joint tenants on a bank account. If you've got life insurance policies, you usually name the surviving spouse as the primary beneficiary, and then usually you name a contingent beneficiary. Usually it's your kids. Same thing with retirement accounts. Beneficiaries override wills. Deeds override wills. So even though your daughter is on the checking account and you've directed her in the will to divide it up, that actually does not have any legal effect. That bank account becomes hers once you have passed. So if she's a good person and she does what she says, which I'm sure she is, that's exactly. Or what if she passes away? Mm-hmm. But if that is her bank account, so let's say you die on a Tuesday and she dies on a Wednesday, so she's inherited that bank account and it's just going to go to her heirs. It will not go to whoever else you've designated it to. So that's important to remember. Beneficiaries override wills. So I'm 100% in favor of putting kids on bank accounts. I think it's a great idea. It's just something to remember that they could end up controlling your entire bank account. Now, if you only keep enough in your bank account to cover bills, we don't worry about it. But if you're somebody who keeps $100,000 in your checking account and you've got one child on there and all of a sudden one child ends up as the sole owner of that, you're going to have a lot of upset children coming around. Unless you've got a really nice daughter who says, don't worry about everybody, you're going to be taken care of. So, providing they don't skip town with $100,000. So.
That happened with my grandmother. My grandmother had put my father on her banking accounts.
Mm-hmm.
And of course, her will says she wanted her savings account divided among her grandchildren, 7 grandchildren.
Mm-hmm.
But the attorney told him, he said, this is your money. You don't have to give him a dollar.
Exactly.
Now, Dad did.
Good person. He did not have to. That's exactly it. The do not have tos. And unfortunately, you're not here to enforce that. That's the hard part about it. You know, we think she's great. We don't think she'd ever do that, but you're not here. So we want to set it up in case something happens to her so that it's right where you want it to be. You can put her down as a signatory as opposed to putting her as a joint tenant. You can put more of your children on as a joint tenant. You can do that. You can keep less money in that account and maybe move more of it into a savings account and put all your children on it as joint beneficiaries. Yeah, you can put as many people as you want on a beneficiary. I don't think they have a limit. So yeah, if you've got CDs, that's a great way to do that because then that money goes automatically to them. And again, non-probatable because they have beneficiaries. If they don't have beneficiaries, they got to go through your probatable assets. So you've got to list them. So we've talked about that. We've talked about how important it is to have a will that names an executor. Now, since we're talking about holographic wills here, how many executors did you name? Just the one? I want you to add another person. You want to have that backup person. Always have a backup executor. Oh, perfect. Mm-hmm. Okay, I like that. Good. But make sure that the bank will do that, though. Okay, because we've had problems with the banks recently. Banks anymore, because they charge money to execute people's estates, if they are not at a certain level, the banks have been refusing to be people's executors. So if you've talked to somebody, that's great. I honestly, I can't guarantee you.
I talked to a person from the bank that's responsible for the disputes, the person who took over the bank. He said that they locked the door as soon as they got into the bank. They're not allowed in.
That's the bank system. Right. And did you, well, we're going to get back to that because we're going to talk about how you make sure that kids who don't want to inherit don't inherit. So, but let's finish. Right. So, yeah, so we'll get back to that. One of the other things people ask me all the time is, what's the difference between a basic will and a living will? A living will is the thing that you can write out that says, I don't want you to put me on a feeding tube. I don't want you to put me on a ventilator. You know, don't do any extraordinary measures. And I usually tell people those are not necessary if you have had a good discussion with your medical power of attorney. It's actually more important for you to have a medical power of attorney who knows what you want to do than it is for you to have a living will where you've written out. Because hospitals can get very leery about living wills because sometimes they can be what they consider to be too old. So if you executed a living will 20 years ago, but then you've got a daughter that comes along and says, you know, she changed her mind, they're going to go with that daughter because that's a person saying it as opposed to paper. So keep that in mind. It is more important for you to have a medical power of attorney that you've had that discussion with than it is for you to have a living will in place. Okay? The other thing here, where I say, why does Susan hate codicils? That's something people always ask me. They'll do a will in my office and then they'll say, well, I want to make a change to it. Can we just do a codicil? I hate codicils because they're like chapters after a book. You know, we've written the book, it looks great, everything's awesome, and then you come to me and you say, you know what, I've changed my mind, I want to update my executor. This person said they didn't want to do it. I would rather do the $50 edit fee than do the codicil because people lose codicils. Sometimes people don't come to me when they want to do codicils, they'll just write them up themselves, and that's okay if they've written them up properly. But if they haven't written them up properly, then Angie at the courthouse can reject your will and say, this is not good. You didn't write this codicil up correctly, so we're going to fall back on what you've already done in your regular will. So that's why I usually just tell people, if you need to make a change to your will, if we've done it, like I said, it's a $50 edit fee, just let us make the edit as opposed to trying to tamp on multiple sheets of paper. Because I've had people do 3 and 4 and 5 codicils, and it just gets really confusing, especially when they start making changes to big things like who they wanted to have this really nice car, or who they wanted to have the bank account, or things like that. It is better for you to have one document that has all that cleanly written out in one big thing as opposed to a will you did and then a bunch of different codicils where you've changed your mind every 6 months. Right. Oh, no. And that's actually, when we write our wills like that, we actually put a little paragraph that says you're going to do a personal list. That's what we call it. You write it in your own handwriting, you sign, you date it, you attach it. That's not so much a codicil as it is a portion of your will. A codicil would be something where, let's say you left your house to one kid and in the original will, and then in your codicil you changed your mind totally and left it to another kid. And then that's where you see those people who get into the arguments about which will really did mom mean? Did she mean the one where she came to the attorney, or did she mean the one that she hand wrote out one night at midnight and just attached on there? So, okay. Any questions about basic wills? Sure.
So if a spouse, say me and my spouse wrote our will together and my spouse dies, what would be the reason that a person would have to rewrite a will to add in children? This happened. Why couldn't they just make an amendment and say, hey, instead of my spouse, now that's dead, make this my children? Should I rewrite my whole entire will?
Well, she should have included that in the first time. See, that's why I was talking about you want to make sure you think about that when you do your first will. So what you do is, I want everything to go to my spouse, And then if something happens and my spouse predeceases me, I want it to go to my children. So it should have been included the first time around. So, yeah. So that's why you want to have that roadmap that says, my spouse dies, I want it to go to the kids. If my child predeceases me, I want it to go to my grandkids. You want to have, we usually say we want to go at least 3 deep. So spouse, child, grandchildren. So, and now that we're talking about grandchildren, that brings us to trust wills. So trust wills sound scary, but they're actually not that scary because trusts aren't that scary. I know everybody thinks that that's like something that just rich people have because they've got so much that they've got to do something with their money. No. Trust wills are really good for two instances. First off, when you have kids who are going to inherit who are going to be under the age of 18, or you have somebody who's going to inherit that is not good with money. So what a trust will does, yeah. We all have that person in the family who we love to death, but if we gave them $5, they would have $5 out of their pocket as soon as you gave it to them. So those are the kind of people that if they are going to inherit a lot of money, thousands of dollars potentially, you want to make sure you put it into a trust. And that is just as simple as a bank account at the bank. You just open up a trust account. You just say, hey, I've got $20,000 here from mom's estate. It's to be used for this person, Johnny. This is Johnny's trust money, and when Johnny needs money, he comes to me and he says, hey, I need some money, and I give him some money. He needs some money for groceries, I give him money out of his trust. He needs me to pay his taxes, I pay his taxes out of his money. It's very simple. It does not have to be super, super complicated. So if you have grandchildren, it's a great thing because if you have grandkids who are underage, you can set it up so that that trust money sits there until they hit to be 25. But we also give our trustees really broad powers. So if you name somebody as the trustee, that's going to be the person who distributes the money out. So if, let's say you have your granddaughter Susie, and you've passed away and you left Susie $10,000 and you said, you know, Susie can use it for anything she needs to, and then once she turns 18, I want her to have all the money that we've got here. So let's say Susie wants to go on the 8th grade trip, but she doesn't want to sell 1 million pounds of oranges to get there. And you're just like, all right, Susie, let's just write you a check for $250 and be done here. Your trustee can do that. If Susie needs braces, she can get the money out for that. As long as you're using it for Susie and not for yourself, again, if you're the trustee who buys themselves a Corvette with Susie's money, Susie's going to sue you, and she's not going to be very happy about it when she turns 18. So that's what trust wills are really good for. If you know that you're going to have really underage grandchildren and you want to make sure that whatever you are giving them actually ends up in their name. A lot of people like to do that in cases where maybe they have in-laws perhaps that they don't want them to trust them with the money. So let's say you would have left $10,000 to your son, but you don't really but if your son passes away, you want it to go to your grandson Braden, but you don't really think Braden's mom is very good with money. So you say, you know what, I want someone to hold this $10,000 for Braden until he gets to be a certain age, and I do not want her to be the person who gets to write the checks. You can pick anybody you like. You can pick another child. You can pick a friend that you trust. If you've got a bank who's willing to do that, you can get the bank to do that. But that's what's good about trust wills. So those are good for people who have, you know, like I said, you do not have to have bukus of money. You just have to have money that you want to protect for whoever it is shouldn't be getting the money right away. Or protect, especially with older people, adults who are not good with money, you can do it for their life, and then once they pass away, whatever's left in the trust goes on whoever you've designated it to. So, has anybody here ever had experience with the trust? Anything like that? You, over here? Tell me about it.
Long stories.
Gotcha. As in you were supposed to get trust money and...
It's very deep.
Gotcha.
Now, on a trust, you can, if you want to be specific, you can. You could say, right, that this money is for such and such's education expenses only.
Absolutely.
And they can't get to it for play or for a car. Like,
Oh,
they
yeah.
have to use it for college, you know, if you wanted to do that.
Oh, yeah,
Not
you-
saying you recommend it, but.
No, yeah, I usually tell people try and be broad because you're dead. Sorry, you've died in this scenario. You don't know what they really need. Maybe they need, you know, because you might get somebody who's like, I'm only going to give them this money if they go to WVU. Well, what if WVU doesn't exist in 10 years? It's not looking good right now. So, you know, what if they're you know, want to go to Marshall? Marshall's cheaper and they can pay for it. So you when it comes to wills like that, and that's something we do want to talk about just briefly here, be open to the idea that you do not want to control from the grave. Because the more stipulations that you put on people from the grave, the harder you make it to get any of their estate work done. You know, if you put a stipulation on that says you can only have this money if you go to WVU and you get a 4-year degree, and the kid is like, I don't want to get a 4-year degree. I'm going to make just as much money going to HVAC school. I'm going to start my own HVAC company. $10,000 would do you great to start a company like that. But if that will says you can only get this money if you go to WVU, you're out $10,000 unless you go to court and have that will reformed. And that's really tough and expensive. Probably about $10,000. So that's something to keep in mind when you're thinking about your will stuff. How much ruling do you actually want to do? Do you want to make it easy so that your family can do the things that they need to do with the money that you have been so generous to provide them for? Because keep in mind, people don't have to leave you anything. They can leave it to anybody they want to. They can leave it to this church if they want to. If they think that's a great idea, leave all their stuff to it. They do not, nobody here is guaranteed anything from anybody as far as their estate goes. That is an absolute gift. So, but if you're going to give the gift, try not to make it so difficult on them that it becomes a burden. Okay?
Did you have a question, Rick?
I was just wondering, what happens to that money, say that child did not go to WVU, and that was the stipulation? What happens to that money?
Usually what will happen is it will go back into the estate, and then it falls back on what we call the residuary clause. So there's always a clause in every will, or there should be a clause in every will that says all the rest and residue of my property goes to, and then whoever you want it to go to. Equally, all my children, or just one person, or whatever. So, but the problem with that is you don't know if he ends up at WVU for however long. What if he decides at 40 years old he's going to go to WVU and get his degree? You can't really get rid of $10,000 almost until he's dead. So then you've got an estate that you've got left open for all this time and $10,000 hanging out there. So that's what I mean when I talk about be thinking about how difficult do you want to make this on the people that you love. So, okay, any other questions about?
Adam? Oh, sorry. Go ahead, Grandma.
It depends. It depends on where they're at. If they're Medicaid level, absolutely. Now, Medicaid trusts are different from just a basic trust will. If you are a person who knows somebody who's on disability, SSI, somebody who maybe as a kid who maybe, I'm trying to think here. If you were somebody who got disabled as a child and who's been getting benefits ever since then, if you inherit a lot of money that goes automatically to you, that can knock those benefits out until you've spent all that money down. So if you send them a lot of money, if you send them $100,000 from an estate and they're somebody who's on Medicaid, they have to spend $100,000 down before they will put them back on their benefits. Same thing. Yeah. Oh, I know. I know, it's a shame. That's why you have to set them up a Social Security trust, because the goal is that it never hits their hands. So that's how you protect them. If you've got somebody who is on benefits, on SSI, if getting any money could knock them off of Medicaid, you want to set up a trust in a way that they never get the money in their hands. That's the goal. You don't write them a check for anything. You pay for their rent out of there, you write it directly to the rent company. You pay for their insurance, it goes directly out of that. They never get any income. That's your goal for that.
Yep.
So yeah, if you've got somebody who's SSI and there's a chance that them, yeah. And it's a good question to ask DHHR, because again, that's kind of dependent on where you're at on the scale. So that's something that they may want to ask their, somebody at Social Security. Mm-hmm. Yeah. Again, it depends. It just depends on where they're at income-wise. So.
Adam, what was your question?
Two questions. The only two I had was, personal liability trust is taken away from neglect lawsuits, defamation, if you were sued, you're in a trust as a trustee, does your liability become not?
Oh, whether or not they can touch your money. So let's say you get into like a car accident or something like that. No, actually, they can get into your trust. They can. A lot of people think that. They think that trusts are...
You can hide money.
That you can hide money, and actually you can't. It depends on how good a lawyer is on the other side and how deep they want to get with you. So if they think that, and especially if you are getting money, given to you. So let's say you've got a trust where you're getting $1,000 a month, you get a rolling amount. I mean, that's income you're getting. That's going right to you. So yeah, They're not a catch-all for hide everything into a trust and then go out and hit every car, down North Avenue. Like, they're, yeah. So.
Did you have a second question, you said?
Well, I mean, trusts are like people, they're all different, and they're personal. There's the ones that we mostly deal with are the basic ones that I've just talked about. And then we do a couple of the special, Medicaid trusts, that kind of thing. It just, it depends. So, okay. All right. So here's the good question that people always ask me. They've heard all my stories. They've talked about the wills. I've thrown some numbers at them about how much, estate planning costs. And again, we're really passionate about estate planning in my office. We try and keep things very, very reasonable as far as, how much it costs. Estate planning can get very expensive. I won't tell you how much my dad paid for his will that he never even signed, but it was an outrageous amount, and I'm still really mad about it. So, especially because, again, he didn't sign it. So he had no will when he passed away. So then, here's what happens when you don't have a will. So you pass away, and you are going to go either up the chain of inheritance or down the chain of inheritance. So if you pass away and you have a spouse, in West Virginia, if you've only ever had one spouse and you've only ever had children with that spouse gets everything. So I know everybody's sitting here thinking, well, this is great. I don't need a will then. If I die first, it'll all go to him. Okay, but what if he's your second spouse and you had children beforehand? Then all of a sudden you've run into the problem of he's 50% of your estate and those children from the other marriage are 50% of the estate. So you start getting into issues. But the easiest thing is if both of you have passed away, if you and your spouse have passed, you passed in the same car accident, or you passed pretty close to each other, everything goes to your kids, which again is fine if all your kids are adults. But what if you pass away in your 40s and your kids are all under 18? Well, now you have no trust set up for them, and they've inherited a bunch of money, and you probably have property that you've not thought about, and they can't sign a deed until they're 18. So what are you going to do with your house? So it can get very dicey. Now, is anybody here not married and has no children? Okay, good. But you probably know somebody who is not married and has never had any children. If they pass away, if their parents are still alive, it will go back up to their parents. If their parents are dead, it goes back up to their brothers and sisters. If their brothers and sisters have passed away, though, it can start going up into their nieces and nephews. It can get crazy really fast. I actually had a person, she had a will. She had one son. She left everything to the husband. Husband passed before her. Husband passed, she left everything to the son, exactly the way you're supposed to do it. Son passed before her. Will's no good anymore. Has to go back up the chain of inheritance. Her piece of property had 46 heirs on it. Have you ever tried to get 46 people to sign something? It's really hard. It's really hard. And again, as the dead person, you don't care so much. As the living person who has to find all them, I can't emphasize enough to you how important it is to have that backup person in there. Because what if, like the case of you, you're the administrator here. You can't close this estate until you get this house sold, or you can't pay any debts until you get them. You've got 40-some people you've got to find. And what if you don't even know where they are? See, people always want to know. They always say, oh, if I die without a will, is it going to go to the estate? No. The state of West Virginia does not have anything to do with your estate unless you are going to pay estate taxes. But you only pay estate taxes if you reach the federal minimum. You know what the federal minimum is for estate taxes? $12.5 million. Now, I hope everybody here has a $12.5 million estate. I'm looking for new grandparents. I'm available. But if you do not have $12.5 million in your estate, or we do predict that the estate tax minimum will go back to $6.5 million, that may be a little more closer to where you guys are at. I hope so. But for most people, 99% of the people here in Jackson County, you're never going to pay estate taxes. So you do not have to worry that the state of West Virginia is going to come in and take your stuff. Don't ever worry about that. The only time the state of West Virginia gets involved is if they cannot find any heirs for you. You died without a will, you had no children, you had no wife, you had no brothers and sisters, you had no parents, you got nobody out there. They cannot find a person for you. That's the only time the state of West Virginia is going to get a hold of your estate. The only time. They will look for somebody who is blood for a long time. A long time. So do not make that hard on people by just saying, I'm just not going to do a will and we'll just see what happens. Because the people who you cared about are going to go, I wish you had never even talked to me. So, all right. Yeah, exactly. Yeah. I mean, yeah, if you really didn't like anybody around, so see what happens. Yeah. Mm-hmm.
Yeah.
Exactly. And we're going to talk about that now, actually. So, obviously, as a legal person, I'm always going to tell you, you want to come into my office and have me draw your will up. Because number one, I know what questions to ask you. I'm going to remember to ask you, if something happens to your spouse, what do you want to do then? Do you want your money to just go to your grandchildren? Do you care if they get it at age 12, if they inherit $10,000 for you? Do you think they're going to blow it all on candy, or do you not care if they do, you know? I'm going to know how to ask you those questions. But the other thing that is good is that you're going to be in my office in front of me as a notary and my 2 witnesses. So if you come to me and you say, I am going to not inherit Billy. We haven't talked in years. I'm not leaving him a thing. I want that in the will, and I'm going to write it in the will. We're not leaving Billy anything. We don't have to say why. We can if you want to. I'm always nosy. But we don't have to. We usually just write, for reasons that are known and personal to me, Billy's not getting anything. So you pass away. Billy comes up and he goes, they would never have left me out. Mom loved me. I talked to her every day. And the other kids are going, we haven't seen this guy in 5 years. And he's going to come to me. And the first thing they're going to say is, was she competent when she made this will? Yes, absolutely. She came into my office and she was specific. She said, I don't want Billy to get anything. And she signed in front of my witnesses. My witnesses are going to say she knew exactly what she was doing. She was competent. She was of age. She knew what was in this writing, and she did it on purpose. And there goes Billy's big legal case of trying to get your will thrown out. That is much harder than people think. Everybody always thinks, because you watch Law and Order and you think everybody gets a hold of a will and somebody's always mad and it's so easy to get one thrown out. It is really difficult to get a will thrown out because you actually have to prove that in that moment, and again, it's only in that moment. You can be as crazy as a bed bug out in my parking lot. You can be crazier when you go back out in my parking lot. But as long as in my office, you know exactly what you are signing, you are intentional to do it, that you are of age, you're good to go. And I'm going to say that, and I'm going to testify to that. And it is very difficult for somebody to come back around and then say, oh no, this person didn't mean that, they were not capable of making a will, because I'm an officer of the court. I'm going to testify to what I saw. Now, if you're somebody who wrote your own will, there's nobody to attest to that. Did she really mean that when she said that? When she made that mark out, did she mean to mark that out? Or did somebody tell her to mark that out? That's the other thing people always come up. Well, when they came in, somebody was encouraging them to do all this stuff. Again, that's something I'm going to ask you. I'm going to ask you, is this your wish, or are you just listening to chatter in your ear from this person? So you want to keep that in mind too. If you're going to write your will, or if you're going to come into my office, it's always a good idea to leave people outside of the office. They don't need to come in with you. But if you want them to come in, that's fine. A lot of people like to bring all their kids because they want their kids to be involved, because they want their kids to know everything out in the open. This is what I intended. We don't want anybody to be unhappy about it, and usually nobody is. So, and I can tell you, again, will contests are pretty rare. Not saying people don't get mad. They get mad and they threaten it a lot. Oh, I'm going to contest it. But it is very difficult to contest a will. So, has anybody here ever been involved in something like that, or knew somebody who was involved in something like that, or knew somebody? Hey, did it turn out in their favor, or realized that it was going to be something hard for him to prove? So, okay. So we're going to talk, so if you don't estate plan, so let's talk about disinheriting. So sometimes when people come in, they say, I do want to disinherit this person either because they don't talk to them or they don't need part of my estate. I do hear that a lot. This person doesn't need my estate. They said they don't want to be a part of it. Great. We're going to put that in there. And you do not need to leave them $1. Everybody always asks me, because that used to be the thing that everybody's like, I'm just going to leave them $1 and that's enough. You don't have to leave them anything. If you want to leave them $1, you can, but then you actually technically have to give them $1. But you don't have to leave them anything to disinherit them. You just say, I'm disinheriting them. You don't have to say why, and that's it. So, okay. So let's talk about probate. So you've got this will. we've done a will for you, you've passed away, you've named your executor. What's your executor got to do? Your executor, first off, needs to find out what all's actually in your estate that needs to be probated. Now, in West Virginia, there used to be one kind of probate, one kind only, and it was the long form probate. And that was the one you did, where you had to go in and you had to write down the big long list of everything you owned, and you had to give everything of value, and then they published it in the paper, and you had to wait for somebody to make a claim, and then if you had to pay the claims, you had to pay money, and only after like 120 days, if you were lucky, then you got to distribute everything out. So, but now they have what's called the small estate probate, which is great because it works in conjunction with the transfer on death deed. So for most people, their biggest asset is their house. So if you have a piece of property in your name only, that has a value of less than $100,000, and you die with less than $50,000 worth of assets, that's a car that's just in your name, maybe a small checking account that's just in your name, you can do what's called small estate probate. So what you do is you wait 30 days, and then if you have a will, you take the will down, and you go down and you attest in front of Angie down at the courthouse at the probate office, and you say, hey, when this person died, they did not have a house in their name because they didn't, because you did a transfer on death deed, so it went automatically to somebody. And hey, all they had was a car, and their car was an old junker car, 2000 Corolla, it was $1,000. She writes that down, you're done. Probate's over. Great. If they didn't have any debts, even better. Now, if they had any debts that come through and you had a $1,000 Corolla, make sure you sell that Corolla and pay those debts off. Because if you don't, you can be liable. That's important to remember. And then the second part of that is if you are a person who dies without a will, you wait 60 days and then you say, okay, they did transfer on death deed, so they didn't own a house. They had $1,000 in a Toyota Corolla. End of story. End of probate. Go ahead.
Well, I just have, if they have bank accounts and they have people it goes to if they pass away, does that money go into probate?
So they own it as joint tenants or
No, it's beneficiaries.
just as beneficiaries? No, beneficiaries do not go into probate. So if it's,
Money goes straight to the beneficiary, or
yeah, so if you have like a CD that has beneficiaries, yeah, that money goes straight to them. It is not part of the,
doesn't go to probate?
no, it's not part of the probatable estate.
Okay, and the deed, you say trumps a will?
Deeds trumps will, beneficiaries trump will.
Okay.
So that's why those things are so important. And that's what I'm really encouraging people to do. Think about what kind of probate you want your executor and administrators to have to do. Do you want them to get to do the easy small estate probate? Absolutely. It takes next to no time. It is no trouble at all. Or do you not care? And you're like, list everything I've got in the world. It's going to go in the paper. Well, they don't list all your assets in the paper, but it does go on record in the courthouse. But that's only if somebody like me sees it. So it's not that big of a deal, but it's more paperwork and it's a longer time.
Yeah. One other question. You said how to safeguard the property. Is there any way to safeguard the assets if someone gets put in a nursing home?
That's kind of a long topic, and it kind of depends on what kind of assets we're looking at. When it comes to nursing home, you're looking at it from two different perspectives. You're looking at it from the perspective of, are you trying to get a Medicaid bed to be in nursing home, as in free nursing home care, or are you just a regular person who's going to be in the nursing home? And those are two different ways. You can protect your assets, you can protect things, but you also have to remember that if you are a person who needs a lot of care, better for you to use your money than your kids' money for that. So your kids would rather you use your money if you are going to be in a long-term facility or need long-term care, as opposed to putting it in a way that nobody can access it until you pass away, because then you have no money. How are you going to get care? So it also kind of depends on what kind of nursing home you want to end up in. You know, if you want to go into the Sweetbriar, which is $15,000 a month, you're going to want to use your money for that. But if you're getting to the point where you don't know what you're eating, you don't know what's going on, maybe you just want, just basically a place to lay your head, you want to give those some considerations. But nursing home planning is a lot different than estate planning. But there are ways to protect the assets, But again, it depends on what you're shooting for. Are you shooting for a Medicaid bed, or are you shooting just to make sure that you have enough money that if you go into a nursing home, you've got enough to take care of you, or that your kids can access it if they need to, or what can we do to kind of lessen the cost on you? So, but the lessening the cost part comes down to what nursing home do you want to end up in. So.
Right, but there's no way to safeguard the money.
There are ways, but again, it's a question of what if you need that money? Because if you safeguard, the safeguard way is get it out of your possession. So that comes back to that 5-year look back.
Yeah, they go back 5 years.
Right, but then what if you need that money and you've given your money to your son and he's like, that's my money, Mom. And I hate to tell you this, but 5 years ago, I blew that money on that Corvette. And now Mom needs it to go into the nursing home.
Can you disinherit your kids if they put you in a nursing home?
If you're capable of signing a will, absolutely. That's yeah. Mm-hmm. Oh no,
You can put stipulations on it, absolutely.
For you children here, I can't emphasize to you enough, there's no law that says you get to inherit from your parents. And I mean that really seriously, because I do think there are kids that think that there's a requirement that says that they get to inherit from you no matter what, and you can't disinherit them. You absolutely can, but you want to be really specific about that. You want that in a will that says, I'm not leaving you anything. Again, you don't have to say why, but you want that in there,
Yeah.
okay?
And probably should say that to some of you, the adults too, for your will, like, you do not have to leave it to your kids.
No.
You do not have to. And you don't think it's like, well, I'll be a scum of the earth if I didn't. No, it's yours. You do what you want with it. Mom does not have to give me 1 red cent. Mm-hmm. And that's how it should be. That's why they call it a will. What do you want? And whatever you want is what you want. So don't feel pressured to do any of that stuff.
Exactly.
So,
exactly. The small estate limit is $100,000 in real estate and $50,000 in all your other assets. That's your car, that's money that's just in, and it's your name only. So it doesn't count anything that you've got a beneficiary on. It doesn't count any transfer on death deeds. It doesn't count anybody who's a joint tenant on a deed. None of that stuff. So, okay. All right. So we've talked about that. Okay. Oh, blended families. So I really can't emphasize enough to you, people who are in blended families, you absolutely need to come to a conclusion about how you want your estate to go. Because here's what I see happen all the time. People get into a blended family situation, they get along, they're maybe not super lovey-dovey, but they get along, everybody acts right. You pass away first, you leave everything to your husband, you don't leave anything to your kids from the prior marriage. Husband passes away, he doesn't have a will. Where do you think all of those things from your estate and his estate go? They go to his heirs. Your kids got nothing. They didn't get anything from your house. Maybe you had a family farm. That's when you see real drama come up. That's the stuff you hear about when you're in the line at the grocery store. Mom didn't leave anything to us. She didn't plan for us. Everything went to, my stepdad Joe, and then Joe left everything to his family. Well, maybe Joe didn't intend that, but he just didn't do anything. And it happened to my uncle. He left everything to his second wife. She passed away within a year of him, and then her house that my cousin was living in went to her son who lived in Ohio, and he tried to sell the house out from under Cousin Sharon. Now, Cousin Sharon, though, she's Logan County proud, so she just stayed there. And he realized he wasn't going to beat her. So he just eventually deeded it over to her. If you're like Cousin Sharon, you can take your chances. But, that's Logan County. It's a little different down here. Somebody will take you out of that house at some point. So, yeah. But if you are people in a blended family, I can't emphasize to you enough how important it is that you talk about what your intentions are. If you have a home together that you've paid money in together, and you've got kids, especially if your kids maybe get along okay, but if you weren't around them, they would not get along at all. You want a roadmap for them more than anybody else. You want something that says, you're going to get 50-50, you're going to get 50-50. You want that in there. It is so important. I tell you, that's probably the number one family type that gets into it. And especially that's why powers of attorney are important if you're a blended family. Because again, like I said, what if you've got stepdad Joe over here saying, put her on everything, give her all the medicines, and then you've got daughter from the first marriage going, she would never have wanted that, take her off there, but they don't know who to follow. So, very important. Okay. Any questions about that? Because I think we've actually got to the end, which is great. Okay. So again, let me go over the 5 takeaways here, which I think are the most important. Your home is always going to be your biggest and best asset. Protect it at all costs. Do those transfer on death deeds. If you don't like the transfer on death deed, we can talk about doing a life estate deed. Maybe that's better for your situation. Because remember too, everybody's probate is going to be different because everybody's life is different. Everybody's estate is going to be different. So that's why it's important not to get form things off of the internet, because they're not going to be personal to you. Okay. Hey, powers of attorney, they're not optional anymore. They are a necessity. Get those powers of attorney. Get the free ones from the hospital. You can come to my office and get a power of attorney. I don't think anybody in the county charges very much for them. Like I said, we charge $75 for our durable powers of attorney. Because remember, trying to be somebody's guardian conservator can get very expensive and it's very time consuming. Okay. Hey, and again, wills are not about how much stuff you have. That's what all the younger people always say to me. All my friends who are my age, they're like, Susan, we don't have anything, you know. Or you don't have anything right now, but you're going to have something. Also, you have a house. That's something. I don't know why all my friends act like their houses aren't anything. I think it's because they all have mortgages. So they're like, this isn't mine yet, so it doesn't count, right? No. You've got stuff. Think about where you want your stuff to go. That's important. Fairness over equality. That's something I try and emphasize to people, especially as more and more people's children don't live in Jackson County anymore. So maybe you have one child that lives in Jackson County, lives on your 100-acre farm, helps you do the hang, loves it out there, runs cattle, does their whole thing. And then you've got a child that lives in North Carolina, has no intention of ever coming back here to Jackson County. So let's say your 100-acre farm, if you were going to sell it tomorrow, you'd sell it for $200,000. And let's say you have $200,000 in a CD. Why not go ahead and execute a transfer on death deed to your son for the $200,000 farm and then leave all your $200,000 in money to the child who's never going to come back on the farm? That makes things so easy. As long as you don't go to the nursing home. Exactly. As long as you don't need that money. And that is something people ask me. They're like, oh, you know, but what if they have less money? What if they do? Maybe they don't care. And like you said, there are some kids who will just say, I don't need your money, Mom and Dad, and I don't need your property. Talk to them about it. If they say that, take them at their word. Say, I'm not going to leave you anything. If it doesn't hurt their feelings, let's do it. Okay. So the last thing is, you should, and this is why it's important to have a will, and that's why I emphasize so much about having backups, because you don't know who may end up being the person who has to look at your estate. So you should always write your will like everyone you love is in the same car wreck, everyone who survived doesn't like each other, and someone you don't know has to administer your estate. So, okay. Who's got questions for me? Go ahead.
All right. It's just my wife and I. We don't have any kids. I really don't have any family I want to leave anything to.
Okay.
Other than powers of attorney, medical, and durable. What we need.
You need a will, man.
For what?
You got to figure out what you and your wife are going to do with this house. So if you pass away tomorrow, you have no family you really want to have your stuff to, who do you think it's going to go to?
If I'm dead, it doesn't matter.
No. Well, you don't care.
Exactly.
Right. I mean, I can't argue with the I don't care attitude. Like, but I can promise you that if you're up there and you're looking down and you're seeing people you don't like talking about your farm, you're going to wish that you had done something about that. But you probably have somebody you do like that you would want to have it, or somebody who likes their stuff, or
I love you, Rich. I'm kidding.
Well, I was going to say, you love your church. They could sell your property and do a lot of good with that money. I don't know if you guys know anything about the Jackson County Community Foundation, but a lot of those funds start that way, where people didn't have children to leave anything to, so they start this fund, and look how much good it does around the county. Yeah. So just because you don't have kids and you don't think it's going to affect you, think about what it could do, though. Yeah. You could have a scholarship named in your name where somebody every year is like, this dude left this money, I never met him, but I got to go to college, or I got to go to trade school.
I actually did go to college on a scholarship just like that, you know. Mm-hmm. So it was the same thing a guy set up. But your point, what you were saying, I think it's the same thing. This is my important part of this. Is while we're doing this whole thing, I think an important mentality about this is, like Susan has said many times, like Richard said, when we're dead, we're dead. We don't care. Okay, see, all this stuff we do is not for us. So if we're only thinking about ourselves, then none of this stuff matters. Like, nothing matters. Your funeral service next week doesn't matter. You're not going to be there. I mean, well, you'll be there, but you won't be there. You know, all of this is about, do you care about the people around you, or do you care about everybody else, and what can you do either to minister to somebody else going through it, or to make it easier on the people that you're leaving behind when you leave. And like all of this is, that's why I think this has a place in church, because it's about ministry. What am I doing for the people around me? What am I doing for you guys? What am I doing for my kids? What am I doing for my parents? Because it's not about me, and your life isn't about you. You know, it's Jesus, others, than you, right? So that's why this is important to me, is because some of you have been stuck in a situation where you had to deal with something that somebody else didn't care about, and you had to clean up the mess. And it makes it a whole lot nicer if we can think about that. And not saying you have to. You can do what you want, because it is up to you. But that mentality of, you know what, I do care. I do care because I want to carry that burden for somebody else, so I'm going to do some of this. Now, that's the mentality. I think that's kind of why we brought it into the church, because I think that's the spiritual thing. I think as good stewards, that's what Christ would want us to do. So that's why we're talking about legal stuff on a Wednesday night. But
Yeah. Well, and I'm really glad that I got to talk to you guys, because there are so many rumors that go around. I mean, I know everybody here has heard that the state comes in and takes everything, because that's probably like the number one question when people come in. They're like, is the state going to take everything I own? No, it's not. Only if there's absolutely nobody else that we can find. And am I going to have to pay? You know, some people don't like to inherit. Some people don't like to probate people's estates because they think they're going to have to pay out a bunch of money. And that's just not the case, usually. You know, if that, you are not liable for somebody's personal debts. So even if you are somebody's administrator, if they have the money to pay their debts, they pay their money out of their money. You don't pay your money out of it. So those are important things to remember. And it's important that when you hear people talking about that stuff, that yes, like Joey says, let them know, like, oh, you know, I've heard that you can do this, or have you thought about protecting your house like this? Or you hear somebody say, I don't want to leave anything to those good-for-nothing children of mine, but I know they're going to end up with it, and tell them, oh, did you know you don't have to do that? Did you know also that I am available in case you really don't like your children? So now that may be undue influence, so you're going to want to send them by themselves, but think about that. So, okay. Well, I usually tell people when it comes to wills, you should do them at 3 times in your life. So you should do one when you have your kids, because one thing you want to be thinking about if you're a person who has kids underage, where do you want your children to go to? So right now you're married, and the assumption is that your husband or you would end up being the surviving spouse, and your kids would live with you, and that's great. But what if you die in the same car accident? Then where do your kids go? Do you want him to go to your parents? Do you want him to go to his parents? Do you maybe want him to go to brothers and sisters? So that's when you want to think about incorporating a guardianship into the trust will, and say, hey, I don't want you to get any of my estate until you turn a certain age, and these are the people I want you to live with. Now, I will put the caveat on. Family law is much different from estate law. So over there at the family court, they take into a lot of different factors when they decide where kids are going to go if the parents have passed away. But one of the big factors is for a parent to write a will that says, this is the person I want it to go to. They take that very seriously. So
So do you just write that and then go get it notarized for where you want your kids to go, or is that like the trust will?
it would go as part of the will. We
Just
put
the
the whole
basic
thing
will.
in. Yeah. Well, it would be not the basic. It would be as part of the trust will, because you would want the guardianship and trust to go together, because you'd also want to say, and this is who I want to be in charge of their money. So, because your parents may be great parents, but maybe they're the kind of grandparents that spoil their children rotten. So perhaps their money ought to go to somebody who's going to say no every now and then. Just a thought. So, okay. Yeah. I mean, listen, my
Bunch of
mom
pointing
is the
going on there.
worst, and she knows she's the worst. So that's why she's not trustee. So, okay. Yeah. Okay. Any other questions anybody's been thinking about? Go ahead. Mm-hmm.
My other boy's in another state, he's rich, and I've got 2 grandkids down there.
Mm-hmm.
I want to do something else.
Okay.
So I want to make it equal, you know, to my grandkids.
Mm-hmm.
So how do I leave to my grandkids here?
So how old are your grandkids?
One is 21 and one's 18.
Okay, so they're all over 18
So you
now?
can go straight to it.
Okay, that's perfect. You can leave your property. If you want to leave all 4 of them on the property, you could absolutely do that. But you may also want to consider the idea of doing property to the 2 kids that live here, money to the 2 kids who live down here, because you could open a CD and make the beneficiary a grandchild that they can't get to until they're 18, or a savings account or something like that. A lot of people like to do that. They like to open little money market savings accounts, and every year on their birthday they put $500 in, or $100, or whatever you can afford. And then once the kids hit to be 18, here's a little account form that they can get a hold of, or whatever age you've marked it. I think you can do it through the bank. Not for if you're leaving them just as beneficiary. If she's going to be a signatory and a joint tenant, she does have to be there.
If it's just a beneficiary, you just write that on there. You say she's my beneficiary, but if she is a signer or
an
she's a
actual
joint
tenant,
then she has to be there.
Yeah, she's got to be there. That's the rule. Because she's a co-owner. Well, if she's the joint tenant on your bank account, if you've listed her as joint tenant, she had to be there because she's a co-owner. Now administrators, so there's executors. Executors are people who are executing somebody's estate who have a will. Administrators are for people who do not have a will. Right. So, no. I mean, you mean once you've passed away?
If you use a beneficiary, then it don't even go through that.
It won't go through
It
your
doesn't
program.
matter that she's the executor. They'll pay her before it even goes through executing the will, if she's a beneficiary.
Yeah.
So you can handle that. Yeah, you just go to the bank. They'll just say, hey, here it is. It's the same way as your life insurance or my retirement, any of my insurances. I've named Bobby Joe as my beneficiary for. That goes. I don't need no executor for that.
They drop a
they
death
just pay
certificate
it.
off, and they'll send it to whoever you've got their address for.
Yep.
Absolutely.
Yep.
You can put 4, 10, you can put as many as you want to.
Yep.
So
You can put your pastor always. And I'm just,
there you go. See?
So
All right.
I'm sure if you guys took some notes, I know we're getting close to 8:30, an hour and a half, and I know we got kids back there, some of you parents, I know the teachers want you to get back there and get your kids immediately.
Sorry.
No, that's okay. I appreciate Season. You guys do. She's really good at what she does, and I appreciate her coming and being with us. I know it loaded you up on information tonight. I hope you got some notes or at least have some questions. And if you got things to think about, she's right down at Rob Fisher's office. And she'd be glad to help you set up a meeting with her or whatever, or execute some of this stuff. But remember, the purpose of this meeting is to get your mind just thinking, at least trying to give you tools or to use in your decisions and what you're doing in life. So hopefully it lightens the burden a little bit when we walk through this thing that everybody's going to walk through sometime, one or the other. And so if you've got small questions, I don't want to set up an hour consultation with her tonight. If you've got some little thing passing, you want to say just thank you for coming, or I might want to set up an appointment with you if you got a small question like that. Otherwise, please respect her time. We'll let her go, and then you can deal with her in the professional office down there. But she's very helpful, as you can tell. She'd love to talk to you if you need any help with that. If you want to go to somebody else, that's fine too.
It's fine.
But I appreciate her, and I appreciate the time that she makes her heads think about this. This thing is for you. Do you have business cards or anything like that with you?
You know what? I forgot them. I'm
Okay.
sorry. I always forget them. That's my bad.
It's a Fairplane fraternity thing. None of us think of that kind of thing. I've never even made them. So.
But Joey has my email. If you ever need
do.
my email, get the email from Joey. You can always email me at the office. And like I said, you can call. And then Rob Fisher, if you've ever been to his office, is very walk-in friendly. So if you ever pop in by, if I'm available, obviously I'll come out and talk to you. So.
Okay.
But all my girls are very knowledgeable about this stuff as well. They all have decades of experience doing this. So.
Okay, everybody stand. We'll go ahead and dismiss for tonight. This is part 3. One last part remaining next Wednesday. We deal with the final thing that we got, and we're going to talk about the funeral services. And you may or may not know this, but regardless of whether you want to or not, no matter what your wishes are, a funeral director does have to be involved with your death. So this is just part of it. So we will have Jonathan Sigmund here, who works for Castos. You guys know Debbie and Darren's son-in-law. But he'll be here next week, and we'll talk about what we need to know to help square some of that away. And so if you know somebody else and you want to bring them to these things, again, these educational times has helped us to equip us and be ready for walking through some of this, either